Good to see you.
Okay, the recording has started. This is the Sunshine Ordinance Task Force Compliance and Amendments Committee meeting of November 24th, 2020. The time is 4:35 p.m. On the call of the roll, Member Wong.
Present.
Wong present. Member Wolf.
Present.
Wolf present. Chair LaHood.
Present.
LaHood present. We have a quorum. There are no agenda changes that I know of at this time.
So we usually, Victor, if you wouldn't mind, we usually have Cheryl read in the remote access information.
Okay, give me a moment.
I can just read it in. I've got it in front of me.
Governor's Executive Order number 33-20 declaring a state of emergency regarding COVID-19 outbreak, and Mayor London Breed's proclamation declaring a local emergency issued on February 25th, 2020, including the guidance for gathering issued by the San Francisco Department of Public Health Officer. Aggressive directives were issued to reduce the spread of COVID-19. On March 17, 2020, the Board of Supervisors authorized their boards and committees meetings to convene remotely via Microsoft Teams and will allow remote public comment via video conference. Members of the public may participate by phone or may submit their comments by email to Cheryl, CHERYL.LEGER@sfgov.org. All comments received will be made as part of the official record. Sunshine Ordinance Task Force agendas and their associated documents are available on sfbos.org/sunshine. That's sfbos.org/sunshine. Chair LaHood, would you like me to read the medium decorum also?
Actually, I can read the medium decorum. That's sort of our routine on this. Any member of the Sunshine Ordinance Task Force may call for decorum due to disorderly conduct of meeting participants. Persons who engage in threatening and/or menacing behavior may be asked to leave. Please call the first item.
Next on the agenda is item number 2, approval of the October 27, 2020 Compliance and Amendments Committee meeting minutes.
Members, do we have any comments on the minutes?
Nope, I don't.
Okay.
I'll move to approve.
Okay, do we have a second?
Seconded.
And is there any public comment on the minutes?
Yes, my name is Winship Hillier. I'd like to comment on the minutes.
Please go ahead, Mr. Hillier.
Thank you, Chair LaHood. Item number 4 is inaccurate, in my opinion. It misstates what I said at that meeting. It makes me sound like I said something 180 degrees the opposite of what I actually said. I also think it may similarly misstate what committee member Wolf said at that meeting during that item. And parts of it are grammatically incorrect to the point where they don't even make sense. It's not even possible to make sense. I corrected these minutes. I sent corrections to Cheryl Leger and copied Chair LaHood on November 12th. I'm getting a lot of background noise.
Mr.
apparently
Hillier.
those
I am going to mute the the people calling in, and you need to press *6 to unmute yourself. I will pause the timer for now.
Okay, thank you.
We're still getting background noise. If someone's outside
Give me a
or running,
moment to mute the participants. Okay, Mr. Hillier, you can press *6 to unmute yourself and continue your public comment.
Okay, can I continue now? Just wanted to say my email edits were not incorporated into the minutes. They are apparently not been changed at all. Back to you, Chair LaHood.
Okay, thank you, Mr. Hillier. Board members or committee members, how would you, or is there any additional public comment?
Hi, was public comment closed? I'm sorry. Are we done with public comment?
It is not. No, this is not. This is public comment on the minutes.
Yes, that was my comment. Did that already close?
No. Would you like to make public comment on the minutes?
Yes. Hi, this is Anonymous. My comment is that I could not find this meeting on your audio recording, so I can't really check whether the minutes are correct or not, and that does need to be placed on your website. Thank you.
Just to address that, we've had difficulties and had problems with the server and getting meeting recordings up. Can you hear me?
Yes.
Yeah. So in addition to just getting minutes and things online, we've had a lot of issues, which I learned today have been corrected. So I will take care of everything.
We will double check, be sure that all the minutes are up, and let you know for sure. And in regards to Mr. Hilliard's proposed changes to the minute, may I suggest that we continue the approval of these minutes to our next meeting to allow us time to review those and to submit any proposed changes to the minutes of October 27th for your final approval at the next meeting.
I was thinking the same thing, but before we do that, can we see if there's any additional public comment on the minutes?
Is public comment still open? Is public comment still open?
Hold on. This is public comment on the minutes. Only public comment on the minutes.
Yeah, public comment on the minutes.
Okay. We will take public comment.
Excuse me, if you're not speaking at this time, press *6 to mute your line.
Yeah, public comment on the minutes?
Yes, one moment, please. We are getting a lot of background noise from someone else who is not speaking. If you are not speaking now, please press *6 to mute yourself. If you then need to speak, you can press *6 again to unmute yourself. Could the last speaker who would like to make public comment on the minutes, as soon as I think it's finally quiet, please go ahead and speak.
Are you ready?
Yes, public comment on the minutes?
Yes.
Are you anonymous?
Yes.
No? Yeah, okay. I just was wondering, where do we find what the man submitted? The previous caller said he submitted edits. Where would we find what he sent in?
They wouldn't.
That is.
May I address that? Please note that public comment is not the opportunity to ask questions of the committee. It is an opportunity for you to provide public comment on the minutes itself. But to answer your questions, we will be sure to provide those on the next set of minutes. They were not included on today's agenda.
Thank you.
Is there any additional public comment on the minutes?
I have a public comment on the minutes.
Please go ahead.
All right. I don't know if this is appropriate. My name is Chris Kors regarding file number 19145. In the minutes, it states, quote, Mr. Kors stated that he was provided that recording and transcript of his hearing because he was a former police officer. That is inaccurate. That's what Stacy Youngblood, Sergeant Stacy Youngblood stated. I did not make that statement. That's all.
I addressed Mr. Kors' questions yesterday.
Oh, great. Thanks, Cheryl. I didn't know that. Sorry.
Yeah.
Okay. Do we have any
I'm
additional
done.
public comment on the minutes? Okay, seeing no additional public comment. Right now we have a motion on the table. Would the proposer of the motion like to modify the motion?
Chair Wolf? I mean, Member Wolf.
Yeah, I'm fine. No problem.
I believe that the motion to approve the minutes has been rescinded, and the new motion is to continue the matter to the next meeting of the Compliance and Amendments Committee.
Okay, so
Or,
that's fine. I mean, I approve the rescission and agree with the continuance.
Okay, so do we just continue this to the call of the chair?
It would have to be at the next meeting.
Right. So do
Not the call of
we
the
need to
chair.
vote, or can we just say that this will be at the next meeting?
We need a
Yes.
second.
we need the second to agree with the
Second to agree.
rescission, and then we need, and then we will need a new motion to continue the matter to the next meeting.
Okay. This is Member Wong. I agree to the new motion. I agree to rescinding the original motion and I would like to put forth the new motion.
I'll second that motion.
Okay. I think we should take a vote on this one. Please call roll.
Can you please hold on? Can you, just for the record, can you repeat the now new motion?
The motion is to continue the matter to the next meeting of the Compliance and Amendments Committee.
Thank you.
Okay, please call roll on this motion.
Yeah. That motion. Member Wolf.
Aye.
Wolf, aye. Member Wong.
Aye.
Wong, aye. Chair LaHood.
Aye.
LaHood,
Motion
aye.
passed.
Motion passes. The matter will be continued to our next meeting. Next on the agenda, item number 3, public comment. Members of the public may address the committee on matters that are within the committee's jurisdiction, but not on today's agenda. We have members of the public who wish to provide public comment at this time.
Sure, this is anonymous.
Please proceed.
Good evening. Today I speak on the willful non-compliance with the law by City Attorney Dennis Herrera. Earlier this year, this task force found in case 19108 that Herrera personally violated 67.29-5 by not recording the issues he discusses and locations of his meetings in his calendar, and found that his office in 19044 also violated 67.26 by not minimally redacting email header information. On September 26th, which is 59 days ago, I asked Herrera for a single email. In those 59 days, Herrera has not even determined whether or not the record is disclosable, violating not only your order, the 19044, but the basic CPRA rule in Government Code 6253, demanding that Herrera determine whether or not the public record in his possession is disclosable within a total of 24 days with extension. But instead of denying my request or granting it in whole or in part, Herrera abuses the coronavirus emergency powers he believes were granted to him by the mayor to indefinitely delay production of this 2 to 3 page record under the false pretense of the pandemic. His office could not even respond competently within the CPRA 10-day deadline to declare the extension. More broadly, Herrera continues to violate the basic premise of his office under 67.21I to, quote, protect and secure the rights of the people of San Francisco to access public information and public meetings. He and his office obstruct and unreasonably delay not only my access to public information, but the access of countless others. And whether this defiance of transparency laws is through malice, carelessness, or incompetence is irrelevant, and you should hold Dennis Herrera accountable. Thank you.
Thank you. Are there any additional public comment at this time for general public comment?
I have public comment.
Please proceed.
Okay. I happened to be watching the TV last week, and I turned on the commission, police commission, and they were talking about something that I don't even think was on the agenda. They kept going on, and I think even somebody said we need to stop because it's not on the agenda, but then they just kept going. So is there a way to make that complaint on that online?
Please complete your public comment, and we will provide your answers after you finish.
Oh, okay. Thank you. I'm done. I'm finished. Thank you.
Yes, may I ask that you contact our office and we can provide you information regarding completing a complaint form. You can do that online, or you can download our complaint form and submit it. But you can contact us, and we will provide that information.
Thank you.
Any other public comment at this time? There being no further public comment, last call. General public comment is now closed. Would you like me to move on to the next item?
Yes.
Before we
please
do
tell-
that, should I bow out, Victor, or do you want me to stick around for a bit more?
You can, Cheryl, you can go ahead and go. I got it.
All right, thank you.
Thanks,
Take
Cheryl.
care.
Next on the
Thank you,
agenda is
Victor.
item number 4, file number 20010, complaint filed by Patrick Manette Shaw against the Office of the City Attorney for allegedly violating Administrative Code Section 67.21B and 67.25D by failing to respond to an immediate disclosure request in a timely and/or complete manner.
And are both, is the petitioner here and is the respondent here?
I believe Mr. Manette Shaw is here.
That's Josh. This is John Cote with the City Attorney's Office. I'm on the line.
And I'm Patrick Manette. Can you hear me?
Yes.
It appears that we have both parties present at this time.
Okay, so this is just a preliminary hearing. This is about making sure that the complaint is complete and that we would have the information we need. We'll ask each side to speak for a few minutes, and then we may have some questions from members of the committee, but we will not be deliberating this case at this time. Mr. Manette Shaw, if you'd like to speak first, you'll have 5 minutes as soon as Victor tells you that he's ready with the timer.
I am ready. Please proceed.
Okay, I'll make this as short as possible. If you turn to agenda item 4 in your packet and then click on my complaint, you will see my letter on page 5 of the PDF file, which I'm going to refer to. The issue for this committee is only whether to move the complaint to the full Sunshine Task Force. I am making the allegation that I filed, I want to mention to you, I filed this complaint on January 17th, and it's somewhat sad that it's taken 10 months to even get this committee hearing, because the delay has not been due only to COVID. This committee should refer to the complaint I submitted on January 17th. In the summary on page 5 in that PDF file, I placed an immediate disclosure request on December 26th, 2019. The CAO blatantly converted my IDR into a standard complaint, claiming they needed to conduct an extensive review of the records. And I find it obnoxious that any city department can convert an IDR to a standard complaint willy-nilly. In the summary of the complaint section on page 1, the timeline is I submitted the IDR on December 26th. The CAO converted it to a standard request, saying that they would respond by January 6th. On January 6th, they then invoked an extension to quote unquote search for and collect records, and that they would respond by January 20th. By January 17th, when I filed the complaint, no records had been produced. Although the CAO eventually produced the records, the issue for this committee is whether they should have responded instead of taking 2 bites at the apple. They should have responded to the IDR within 10 days and not then coming back and extending a 14-day extension. So I believe they should have responded promptly within 10 days without invoking a 14-day extension. And that's essentially the issue that I'm putting before this committee for you to rule on that and complaint to the full task force. That's essentially it. Thank you.
Thank you, Mr. Manette Shaw. Victor, are we ready for Mr. Cote?
Yes, he can proceed.
Thank you. Good evening, task force members. John Cote, I'm the communications director with the city attorney's office. I will be relatively brief here. But first, I just wanted to refer you to our written response from February 11th on this issue, and I trust you've read it already in preparation for this hearing. So I'm not going to use my allotted time repeating it, but you know, it should bear on your decision.
And we're in the middle of something.
Daddy is in the middle of a work phone call. No, out. Sorry, the COVID realities. And working and parenting from home at the same time. So with all due respect to Mr. Manette Shaw, as this task force well knows, immediate disclosure requests are specifically limited to non-exempt public information, and that is simple, routine, or otherwise readily answerable. And that's straight from the code. In this instance, what Mr. Manette Shaw was asking for was, in fact, not even existing records. What he was asking for is us to create records for him, which, in the interest of transparency and public disclosure, we have done so. But the real issue before this committee, as the committee knows and the full task force knows, is that under the Sunshine Ordinance, city agencies are not required to create records in response to a public records request. We have done so here, but it is not required of us, and therefore and we're not statutorily required to create them, and so any statutory deadlines do not apply. And I'm happy to answer any questions committee members may have.
Thank you. Committee members, do we have questions for the petitioner or the respondent?
Nope, not at this time.
Okay. Do we have a motion on this matter?
Wait, do I get a rebuttal before you do the motion?
This is we are not debating the matters of the case. This was just to make sure that we have the information we need to decide to send it to the full task force. I believe that the committee members, we have the information we need at this time. So I'm asking them for a motion. Do we have a motion on this matter? Or an initial discussion amongst ourselves?
Yeah, I have enough information. I don't think there's anything more to be made. I think both parties have presented it well, and I would make the move to forward this to the task force for hearing.
Do we have a second on the motion?
Yeah, I'll second that motion.
Oh
Okay.
my God.
Now we will take public comment on the motion. Is there any public comment on the motion?
May I suggest that we also find that the task force has jurisdiction and that the documents are public?
Yes.
Yes.
Are there any
Public
members
comment?
of the public who wish to provide comment on this motion?
Yes, anonymous.
Yes, you have 3 minutes. Please proceed.
Thank you. If it is the case that, as Mr. Cote says, these records did not exist at the time that the request was made, then either they should have responded within the appropriate deadline saying that no disclosable public records exist under the CPRA, or if there were other records, maybe not in the format that was requested by Mr. Monette Shaw, in the possession of the city attorney's office. For example, the final settlement letters that are executed by the other side, for example, which would show the amount, the caption of the case, the amount that was settled for, etc., or maybe canceled checks or whatever it is that the city attorney's office has. Those records are still disclosable. They are still public records. They may be partially or fully exempt under some other law. But it is the case that if any of those records existed, the city attorney's office is required to respond within the appropriate deadlines that disclosable public records. And if their contention is that no such records existed at all at the time of the request, then they should have responded within the deadline to say that there are no disclosable public records. Thank you very much.
Thank you. Is there any additional public comment? Hearing no additional public comment on the motion, please call roll.
On the motion, Member Wolf.
Aye.
Wolf, aye. Member Wong.
Aye.
Wong, aye. Chair LaHood.
Aye.
LaHood, aye. The motion passes without objection. The matter will be referred to the full task force for hearing.
Thank you.
Thank you, everyone.
Next on the agenda is the complaint file. It's item number 5, file number 19145, complaint filed by Chris Kors against the Police Commission for allegedly violating Administrative Code Section 67.5 and 67.21 and failing to respond to a public records request in a timely and/or complete manner. Just to note, on October 7, 2020, the task force moved to continue the matter with the call of the chair, requested that Sergeant Youngblood provide a recording of the closed session of the Police Commission hearing, and request that the SOTF DCA provide an analysis on this issue.
Thank you, Victor. Do we have the petitioner and the respondent here?
Petitioner is here.
And is the respondent or another representative here?
They are online. Sergeant Youngblood did check in the beginning of the meeting.
Okay.
Madam Chair,
Yes.
this is Member Wolf. I'd like to also ask if our legal counsel had provided any written documentation.
Did our legal counsel provide written documentation? I'm
not seeing any in the
not
file.
seeing either.
We specifically requested a analysis on this issue.
Yeah, this is Member Wong. I was looking through the file and I didn't see anything, so I was a little bit worried about this agenda item just because I'm not sure if it makes sense for us to hear it without that advisement.
And Victor, you don't have any information
I'm not familiar with the complaint. I am checking our files to see if there's something in there at the moment, but I'm not familiar with this complaint.
Okay. I'm not seeing any.
I don't think so. And did we also, did we receive any file with the recording? I
believe we did receive, one moment, I'm just looking. Maybe we can ask Sergeant Youngblood if any additional recording was provided since the last meeting.
Hi, this is Sergeant Youngblood. Can you hear me?
Yes, we can hear you.
So the recording was provided to Mr. Kaur's attorney that was requested, but there was no recording supplied to the district secretary attorney. Just Mr. Kaur's attorney.
One moment, please. Actually, task force members, we do have some response in an email thread.
From who?
This was dated Monday, October 26th from DCA Pricewell.
But it's not in the record here.
It is not in the record.
Yeah, without it being, without both parties being able to see it, I'm a little apprehensive. What date was that? October?
This was October 26th.
This is Member Wong. I'm not sure if I'm on that email.
It looks like you are, but this was very early on, so it's possible that. Yeah.
So this was advice that was provided to the task force under attorney-client privilege.
Mm-hmm.
So the question is whether we want to release it or not. That would be the task force's. That would be a task force decision. But we can certainly have discussion based upon the advice provided to us. Okay, so yeah, okay, so I want to refer I don't think I got a response from Mike. I had asked them a question about this. I don't think I got a response. So I think at the end of at the meeting of the task force, we had heard from Sergeant Youngblood that they were not going to provide they were not going to provide the recording. Is that Sergeant Youngblood? Is that correct?
I did not say that at the last meeting, but in speaking with our city attorney, no, we cannot provide that unless we have a court order.
Unless you have a court order, okay. and but the task force found that it should be released. So my so let me just ask you, Sergeant Youngblood. Let's see. So there is a section in the code in the administration code, section 67.8-1, which regards it's titled "Additional Requirements for Closed Sessions," and it speaks about how long or the retention of recordings. So the first requirement is that it be held. If there was a recording, it shall be held for at least 10 years. We know that the recording exists, so we're not concerned about that. The next point is that the closed session recording shall be made available whenever all rationales for closing the session are no longer applicable. So I'm going to ask you that. Has this case or this issue been finally closed by the police department or by the city?
Well, not entirely, because Mr. Kors has a lawsuit against the city at the moment.
That's okay. So
I'm not aware of that.
So are the rationales? I'll ask for comment from Mr. Kors after I'm done with this line of questioning. So is this case now, like, is it done with the police commission? Is it over?
He has been terminated and the appeal has been denied. So in that case, then yes, it has been completed.
Okay, so is there any reason for for this matter under closed session to continue to be closed? And if so, what's the rationale around that?
The document is a personnel record, not a public records. It is part of Mr. Kors' personnel record, so therefore under 832.7, it is not releasable.
Okay, thank you. The next provision is recordings of closed sessions of a policy body covered by this ordinance, which the police commission is, wherein the justification for the closed session is due to, quote, anticipated litigation, unquote, shall be released to the public in accordance with any of the following provisions. 2 years after the meeting, if no litigation is filed, or upon expiration of the statute of limitations for the anticipated litigation, if no litigation is filed, or as soon as the controversy leading to anticipated litigation is settled or concluded. Are you at that point?
We are, so under 832.7, since the police commission voted not to disclose these records, and it's part of a commission closed session for a former officer's his records, we do not release that. And this is per the city attorney who I spoke to.
Okay, so then let me ask you this. Mr. Kors is he's a party to the issue?
Correct, and we have released it to him and to his attorney after he signed a waiver.
Okay, thank you. Mr. Kors, have you received all the information that you were expecting that we had discussed at the task force meeting?
No,
Since the task force meeting?
No, I received the exact same recording that I've received in the past without the deliberations, without Ashley Worshing's statements, and the anomaly. That's all.
Okay. So back to Sergeant Youngblood, why wasn't the full meeting and or transcript provided to Mr. Course?
Mr. Coors is stating that the anomaly is that we are providing him a record that has been altered. That is his claim. That is not our claim.
Okay. Okay. Okay, I'll stop there. Thank you. Back to you, Madam Chair.
With regards to whether the audio has been altered, I'm not, and this is just discussion with committee members, what mechanisms would be available to us to even determine that?
But without legal counsel being here, I can only offer layperson's response to that, and that would be, well, first of all, it's a personnel issue. So the question of whether anybody outside the confines, that's something that has to be analyzed. I don't have a direct answer for that. With regards to certain personnel issues, state law has changed with regards to the release of police conduct records. I don't know if this is applicable in that sense, but those laws are now kind of the law of the land of California. And it goes back, and if it is being withheld because of there's some other citational law that allows it to be withheld, we're back to our usual issue of not being able to see things in camera.
Well, and the other challenges, and we've run into this before, where people come to us regarding their personnel records, which other members of the public would not be able to request the same information, but they are able to access it because it is about them.
Yeah, the question for us is, what's different about this issue is that personnel matters in government provide are to be when a decision has to be made by the oversight body. Here it's the police commission. They're there to do it in a closed session. I believe, let me just make sure under the ordinance. Let's see. I believe under personnel issues, employee actions, action taken to appoint, employee, dismiss, transfer, or accept the resignation of a public employee in a closed session pursuant to Government Code 54-957, which shall be reported immediately in a manner that names the employee, the action taken, and position affected. This is in the disclosure after the closed session. Okay, that's not the, I didn't want to get that. I want to get the reasons for closed session, permitted topics. Okay. Okay, to consider appointment, employment, value, or dismissal. If the policy body has the authority to appoint, employee, dismiss, to hear complaints or charges brought upon an employee or another person. The body may exclude and shall exclude from any such closed meeting during comments, blah, blah, term employee should be used. Okay. what I'm looking for here is whether I believe in some cases the employee has a right to have the closed session be heard publicly. We're speaking after the fact here. The meeting already happened. I just wanted to see if there was any. Yeah, that's not here. Okay. So yeah, at this point I don't. I think frankly I think this needs to be moved into moved to another venue like a court. I don't believe we have enough authority to be able to compel the item at this time, especially when a citation of another law, specifically around personnel, has been cited. Now, whether we can't not tell, and frankly, this is a body that cannot swear people in under oath, though we expect everybody to be, on their, to be telling the truth. So we'll assume that. But we can't tell what has been originally recorded and what has been possibly or allegedly been edited. I don't know how that would be determined here, except for it to be presented in a court where the court can actually demand it to be disclosed, and it could be seen in camera at that time, based upon whatever the challenges are from one of the other parties. That's kind of where I see things. I don't have any other. Yeah, there's nothing else that I can see in the ordinance with regards, and based upon what we had discussed at the task force level.
This is Member Wong. So I just wanted to make a quick comment about how you might pursue getting this information via the legislation that you had mentioned, or that Member Wolf mentioned, which is through SB 1421, which is the Peace Officers Release of Records, which is a state law. And that actually specifically addresses discipline and release of records for peace officers in the state. So,
do you have the section of code on that?
Yeah, so Senate Bill number 1421, it says Chapter 988, an act to amend sections 832.7 and 832.8 of the Penal Code. So there's actually a statement in there that says existing law describes exceptions to this requirement for investigations or proceedings concerning the conduct of peace officers or custodial officers, and for an agency or department that employs those officers, conducted by a grand jury, a district attorney's office, or an attorney general's office.
Okay, I just want to say that we want to make sure that we're operating here on compliance within the jurisdiction of the it's based upon the issues that were brought forward at the task force level. I mean, we found that the items should be released. The police department is denying that. the task force found that the item should be released to Mr. Kors.
That was released to Mr. Kors.
Right. But he's stating that it was not complete. You're claiming that it is complete, that there was no edits.
Correct.
Okay. Mr. Kors, what leads you to believe that there were any edits?
Well, first of all, I specifically remember Ashley Worsham's statements that she made in that hearing, and I was flabbergasted by them. So they're not in the hearing, and where there was that cut, the sound blip, that's exactly where those statements are missing. Secondly, I thought this was supposed to be one continuous recording. It was broken up into two separate recordings. The deliberations weren't even in the recording, and you can tell by the recording, either one of the commissioners states, hey, this needs to be on the record. And they say, oh, but the court reporter stepped out. But yeah, but it needs to be on the record. And then it just cuts. And nowhere in the transcript does it document the time the court reporter stepped out or the time she returned. In fact, according to the transcript, they're like she never left at all. Oh, this is really concerning. So regardless of what Stacey Youngblood claims, it's obvious that if you don't believe me, it's obvious that the deliberations should have been in it, and they're not.
Let me ask you something, Mr. Kors. Let me ask you. So you were in the closed session?
Yes, I was there.
Okay. So you have direct experience of this that you're explaining to us. Are you do you know if the recording when the court reporter left that the recording was still happening, or was the recording stopped?
I don't know. All I know is what I received was two separate audio recordings, and I believe it should have been one continuous audio recording. I don't know when the court reporter stepped out. All I know is that she wasn't present. So she could have stepped out 5 minutes into the hearing, 10 minutes into the hearing. Who knows when she stepped out? Doesn't document the time. Doesn't even document that she stepped out. So it's supposed to be a contemporaneous transcription. Well, how can it be contemporaneous? The court reporter's not even there. Ridiculous. Anyway.
So I'm sorry, Madam Chair, go ahead. I don't want to interrupt.
I was going to say the challenge here is that both of these things could be true. It is quite possible that what Mr. Kors describes is not in the audio. It's also possible that the audio was not made continuously. We don't know that, and so if audio was if the audio that exists was provided, it is quite possible that the audio that exists was provided and that it was non-continuous. If that's the case, then it's unfortunate, but there's nothing more that we can do. And I don't. I
have another question.
Mm-hmm.
I'm going back to, again, section 67.8-1 for additional requirements for closed sessions. I mean, it's very clear in the ordinance that closed sessions shall either be audio recorded or audio and video recorded in their entirety. Mm-hmm. So let me ask Sergeant Youngblood, without revealing any of the details of the meeting, I'm just going to ask about the time code of the meeting. Is the time code complete from the time that the body went into closed session to the time that they came out of closed session?
So the way the closed session is recorded on the at that point in time, it was recorded on the equipment at City Hall. So when there's a hearing and we have multiple items that will be in closed session. We might have a discipline hearing, then we might move into another discipline hearing. So we don't record everything all in one track, because if somebody's going to ask for a disciplinary hearing, then we need to have that readily available, whereas we can't cut other stuff and redact audio.
Okay,
We do not.
that's not what I asked. I asked from the time. Go ahead. Sorry, go ahead.
When Mr. Kors comes into his hearing, the video recording would begin and we would start recording that. When the commissioners then excuse all parties and they go into deliberations, recording is stopped and the court reporter is asked to step out as well. At that point in time, I believe from that recording, they started to talk and remembered that they needed to bring everybody in. So the recording began again, the court reporter was brought in, and Mr. Kors and his attorney were brought in for that part of the recording. That's why you have two recordings.
Okay, so but there's a period of time in between the two recordings that is the meeting is continuing. They're having deliberations between them, and is that part recorded?
That is not recorded.
Okay, so that's the violation here. Okay, the law requires that all closed sessions be recorded in their entirety, not part of it, and not because it's deliberations, because they want it. Who knows what they're talking about at that point? So that's not applicable, and I don't know why the court reporter would be excused from the meeting. I don't know what that's all about. That's something else. But I think clearly here, what was missing needs to be provided to Mr. Kors, because it is in violation of Section 67.8-1. It doesn't matter whether it's personnel or not. You already provided him with the partial recording. You need to provide him with the rest of it.
But if it doesn't exist, then there's a violation, but there's no recourse.
If it doesn't exist, they got a bigger problem.
Mm-hmm.
But as far as even whether it is protected and can be withheld from public disclosure is not at issue here. What's at issue here is whether it was properly recorded or not. They've already agreed to, and it's part of a closed session, which is part of a public meeting, but is not disclosable to the public. But it is part and parcel to a public meeting. It's not an administrative meeting. It is like the actual decision makers have to, are in session for this. And there are requirements so that the public knows that it's closed sessions are being managed properly. So if there was a part that was recorded with parties, and then the parties were excused because of they wanted to deliberate, it doesn't mean turn off the tape recorder. That's not what the law says. So let me ask again, Sergeant Youngblood, is that part of the meeting where the deliberations happened, was that retained in a recording?
No.
It was not. Is it retained in any deliberations for these purposes?
It's kind of hard to answer. Yes, it is.
So you do it in some closed sessions, but not other closed sessions regarding personnel matters?
Well, I was not at this particular hearing, so I can't tell you what the practice was at that particular time, but There is, yes, we usually record, like I said, in different tracks. It would be that section, deliberations, then the next section, all three different tracks. It's recorded now, yes. That one was not.
But in Mr. Corr's case, the third track was not recorded?
In the Coors matter, the deliberations were not recorded.
Okay, do you know if there was some decision that was made not to do that?
I do not know that.
Okay. Thank you. So I'm a little disturbed by this, and Madam Chair, and I mean, I think it goes to possibly a larger issue as far as consistency, because matters as important and as personnel issues, whether the content is disclosable or not is not really at the matter here. The matter here is whether the closed session, which may need to be reviewed for one issue or another, was not made in a complete manner, which is still in violation of the ordinance. So I think I need a moment.
I mean, I'll give you a moment to, while you're thinking, Member Wong, do you have any additional thoughts on this? I mean, it does sound like we have honed in on something that should be considered by the full task force.
This is Member Wong. I don't have any other comments, I don't think, other than just that we definitely would need to kind of separate these concerns. I think a violation of 67.8-1 is certainly separate from the release of the record itself. So
correct.
We're looking at the record itself versus like the release of it. And I don't know if does it matter that the complainant came forth with like a violation of something that we're not finding, or how
No,
does that work?
No, I think what we're at here is that the task force had found that not the entire recording was provided to Mr. Kors, and so so Mr. Kors received part of the recording, not all of it. Okay, and so now what needs to be finished here is the production of the rest of the recording.
But if it doesn't exist, we've got another problem.
Right, but it also lends to a larger issue. Is this consistent with the regular policy of the police commission, or whether this was an isolated issue? Let me ask Sergeant Youngblood, are you present during these meetings?
I am the police commission secretary, so yes, I am.
And aren't you the one that controls the recordings?
Yes, I am.
And were you ordered to turn the recording off?
I was not at this meeting.
I'm sorry, can you repeat that again? It was jumbled.
At the time of the Coors hearing, I was not the commission secretary, so I was not at that meeting.
Ah, okay. Okay. Who was the commission secretary at the time?
There was two sergeants plus the commission secretary plus two sergeants that were training, so I'm not exactly sure who the secretary was at that, or who was manning that particular time. It could have been a couple of them.
So I'm pretty sure that your minutes would have a record of who was present at the meeting.
Yes,
but I do not have those with me.
That's fine. We can certainly review those. They're public information. Okay, so yeah, I think, Madam Chair, I think, yeah, I think this needs, at least in light of this, we should refer this back to the task force. I think there's, the violation is continuing. We can only go by the word of Sergeant Youngblood, who is not at that meeting, whether there actually a recording of the deliberations exists or not. He only has what's available to him that is within the record. So I don't know if he has any access. We can ask him to any additional records, but it sounds like if the recording was turned off at that time, I think that might be of interest to the task force.
Yes, I'm looking at this now. I don't know that I don't think we have a determination yet. I think this came back to us because we needed more information. We don't have a determination yet. So it was continued in order to get more information about the case.
Oh, right. Okay.
So we would be sending it back. Yeah. So
it makes no difference. It's fine.
Yeah. Just for precision.
Yeah, that's fine. Again, so still my same line of thought here. 67.8-1 requires that the recording be made in its entirety in a closed session, no matter what the issue is. All closed sessions of policy bodies. The police commission is a policy body, definitively, by definition, and that we don't. And Mr. Kors is stating that there was a period during the meeting that was that is supposedly missing. I think what we need to get is from the police commission is a record of the time code of the recording for that meeting. If it's on it doesn't matter whether it's on the same track, different track, whatever it is, however they do their recordings, we need to see, and we need confirmation of the time code. And there are ways to show that without having to reveal the actual audio. You can show it in a visual waveform. So I'm an audio engineer, so you can see audio visually. You can't tell what's being said. It just looks like sine waves that are going up and down. But you can at least see the time code for that stretch of time and whether the recording had stopped and then began again. And it'll tell you what the time code is, so you can see if there was a gap. And from the testimony of Sergeant Youngblood, they don't have a way to do edits. So if they in fact don't have a way to do edits, then this would definitively show that whether the recording is actually still there or whether the recording had been stopped. And
do we also need to find out from Sergeant Youngblood, or and perhaps he needs to consult with others, whether this is a consistent policy for all similar meetings like this, or is this something that is decided on the fly? And we need to know whether it's being applied consistently or not, and whether the way it's being applied if it's being applied consistently, whether it is being applied appropriately or not.
Yeah, correct. I mean, it's really on the commission itself, because the commission approves and creates its own, rules. as far as governing rules for how they operate. So it's what we're asking Sergeant Youngblood here for is information as the representative from the commission, but it's really on the commission because that's what this case is. The party is the commission, not Sergeant Youngblood. So. So that would be the yes. I think it'd be appropriate for us to ask for the police commission's their governing documents with regards to holding personnel issues in closed session if they have a written procedure for it, so on and so forth. We did hear testimony from Sergeant Youngblood right now. That this is perhaps an unusual situation, but not all personnel matters in closed sessions do not. Not all of them do not include. I'm saying double negative here. Not all closed sessions on personnel matters do not have. The deliberations not recorded. So putting it in the positive, there are some closed sessions for personnel matters that do have recordings of the deliberations. So there's some inconsistency here with regards to the application of 67.8-1 of the Sunshine Ordinance, and we've not heard any other citations from the police department that would allow the withholding of the deliberations during a closed session. I'll just note that for the record too.
Okay.
So I can confirm for you that we have checked about that recording, and that recording does not exist for deliberations. There's 2 tracks, but the deliberation track does not exist. It was not recorded.
So I'm sorry. Who is just speaking?
Sergeant Youngblood.
Okay, thank you, Sergeant Youngblood. So sometimes a little hard just hearing voice. So let me ask you, when you start a closed session, is that all on one track, or are you still recording on multiple tracks?
Well, in the era of COVID, we are recording everything in one because we're doing it virtually. So everything is recorded all at once in closed session at the moment. But when we are at the Hall of Justice, there is a start and stop button that we would hit whenever we would go into closed session to go from one item to the next.
Okay, but I think my question is when you are in closed session and you are now recording on a different track, are you recording on one track or on multiple tracks?
I guess it kind of depends on who's doing it. When I am doing it, there's going to be multiple tracks. So it's going to be, I hit stop, and then a new track is formed, and I hit start, and then that becomes the next track for a different item or a different session on the same item.
Okay. So you can hear everybody speaking on that new track. You can hear everybody in the room speaking, correct?
Correct.
Okay. There's not. So I just want to make sure we're both understanding. I want to understand what the term track means, because for me it means something, maybe something different than what you're explaining. So with regards to audio, you can have multiple channels in the same recording. Each one of those channels is called a track, and they can operate simultaneously in the same time code in the recording. Okay, and you can have adjustments for each one of those tracks. So for instance, if every microphone could have its own track, and then you can turn off one microphone, but you'll still hear all the others. So that's what we refer to as like multi-track recording. If you're talking about creating a new track for the all the recordings, it's like all you can hear, all the microphones in the room are now recording on one track, but you could now stopped that track, and now you created a new like audio recording. Okay, you can call that a track as a new audio recording, but now when that begins, you still hear everybody in the room. Is it the first one I explained as multi-track, or is it the second one as I explained in everything being consolidated?
It would be the second one.
Okay, great. So for the second track, when the closed session began and the second track would be started, okay, that goes from, time code one, like for instance 100 to 200, okay, and then when it gets to the end of 200 and the police commission says, okay, we're gonna now go back into public session, then you stop the recording and then you start another recording for the public, for the track that is meant for the public. Is that correct?
Yes, that is correct. So you would stop it. So you record 1 or 2 minutes, you stop, you go to the next one, you hit record again, you go 1 minute to 2 minutes. There's no it's not pausing the track, it is stopping the track and starting a new recording.
I got that. Okay. So the other question I have then is for, let's call it track 2 closed session. Okay. From there, that there is that track is available, right? That's what you provided, Mr. Kors, correct?
I guess you could say that Mr. Kors' termination hearing would have been 3 tracks. There would have been the initial part, which was recorded and given to him. There is the deliberations, which was not recorded. And then there would be after deliberations where they announced their decision, which was recorded and given to him.
Okay. And were those 2 separate recordings?
Yes.
Okay. That's what I wanted to get at. Okay. So you actually have track 1 is for the public, track 2 is for the closed session, track that was the beginning of the closed session. Track 3 is for post deliberation closed session.
No, tracks would only be for closed session. We don't record open session. SF.gov TV records that and then puts that online. We only record closed session because SF.gov TV is not in the room. There's no video cameras. There's only that recording equipment. So whatever is on first on the agenda, whether it's a disciplinary hearing or whether it's a policy, that's track 1.
Got it. Okay, got it. So anything that is not publicly available on SF.gov TV that you would consider to be confidential or in a closed session would be on an audio track. Is that correct?
That is correct.
Okay, got it now. Okay. So at the time that the audio recording began to the time that they went into deliberations, what happens at the time in this particular meeting? What happened at the time when they were going into deliberations? Who stopped the recording?
I don't know.
Okay.
I would have to see who was there.
Okay, great. I just wanted to get clear on that point. Okay, thank you. All right. So yeah, I have nothing more to add at this point, except that I think this information should be forwarded to the task force.
Okay. Member Wong, anything else, or do we have a motion?
So I move that that to recommend to the task force to that there was a apparent violation of 67.8-1 for not recording the closed session in its entirety.
This is Member Wong. I'll second that motion, but I would also like to note that I want to make sure that the full task force does get the information and advisement that we received from DCA Price Wolf. And
Right.
I'm not sure if we can make that public, but it's something else for them to consider.
Well, once we get the information from DCA Price Wolf, then we can determine whether we want to make that public or not at the task force level. But I do want to add that I'd like to request of the police department, of the police commission, I'm sorry, of the police commission to provide us with a time code of the complete meeting. That includes the closed session and the time code of the closed session itself, as it was recorded on the medium. If that's not something that the police commission can provide itself, then I think we should seek to engage Department of Technology for assistance.
I'd also like to request if a policy exists about if a policy exists about whether parts of closed sessions are not to be recorded, we need to know what that policy is.
Okay, so let's consult. Let's create a list here for this. Piece of paper out here. Okay, so one recommendation of 67.8-1, not in entirety. Recording not in entirety. To DCA Price Wolf advice. 3, we wanted policies on closed sessions.
Regarding recording of closed sessions.
Regarding recording of closed sessions. And 4, we want the timeline of the time code of the meeting, including the complete time code of the closed session. Anything else? Okay, so let me restate. The motion is to recommend to the Sunshine Ordinance Task Force to find that there's an apparent violation of 67.8-1 for the recording of a closed session not being in its entirety. 2, that the task force is to receive the advice of legal counsel on this matter. 3, and that it be made available to the task force prior to the meeting, and that there should be some decision as to whether it should be released publicly or not. 3, what is the police? We want the police commission's policy on recording of closed sessions. It's all closed sessions. And 4, request of the police commission a time code of the meeting, including the complete time code of the closed session in relation to Mr. Kors.
Do we have a second on the motion?
Sorry, can I just also just amend item number 2 slightly, just to say that I want to ensure that the memo that we got on October 26th is included in the packet, just because it wasn't for us here.
Can't do it. The reason why is because it's being held under attorney-client privilege.
I see.
So it would have to be provided to the task force. I'm not sure what the process would be. I don't know whether we would have to do it in a closed session or whether the task force can review it ahead of time because it's held under attorney-client privilege. The task force can then determine during the meeting whether to release it publicly. Whether it gets released publicly or not, to me, is not. I shouldn't say that it's of no consequence. It's not kind of the right term I would use or phrase I would use, but it's really advice for the task force to be able to help inform and educate as to what the best way forward were to be. The fact that we're many individuals on the task force leaves everybody with a different perspective or interpretation of that advice to be able to ask the right questions or not. So
I more just wanted to ensure that the task force is reminded to read that prior to the meeting, just so they have that information.
Okay. Well, I guess then the point is that to assure that the task force administrator forwards the advice letter to task force members, and that the task force should determine when this returns to the task force whether that advice should be released publicly or not.
Okay, so we have a motion. Go ahead.
I will second the motion as is then.
Okay, now we'll open this up to public comment on the motion for members of the public not party to the case.
Yes, anonymous.
Are there members of the public who have public comment on this matter?
Yes, this is anonymous.
Please go ahead.
Thank you. There's 3 issues here. First, I was at a prior hearing of this file before the full task force, and it's a bit confusing why 67.8-1 kind of had to come up again today, because the full task force's chair mentioned this same exact issue at the full task force. I believe Sergeant Youngblood at the full task force said they don't have a recording of the deliberations. And so it's a bit confusing why I guess it has to come back to this committee, then go back to the full task force, because to me that violation seemed obvious when your chair discussed it with Sergeant Youngblood at the time of the first meeting. I would say it's quite appalling if this is a regular practice of the police commission, because it means that we don't know what injustice goes on, both when the commissioners incorrectly discipline police officers and if they incorrectly don't discipline police officers. We have no idea what they did behind closed doors, and we will never know if it wasn't recorded. And they mentioned, as a separate issue now, they mentioned Penal Code 832.7. But as Member Wong said, SB 1421 explicitly modified the Public Records Act by adding exemptions to Penal Code 832.7, where if Mr. Kors is arguing, and I don't know if he is arguing, that the allegations against him were regarding specific types of conduct, including great bodily injury or dishonesty, and I don't know whether the allegations against Mr. Kors do involve either of those, then this should be completely public, not just to him, but to everyone. Sorry, completely disclosable, not just a public record, but it's a disclosable public record. I have no idea, of course, whether Mr. Kors wants to argue such a thing. And the third point is you absolutely should be able to find a 67.81-1 violation, even if there is no recourse, in order to force the police commission to change. And also because Mr. Kors did allege both a public meeting violation and a public records violation, not just a public records violation, in his original complaint. So I strongly support this motion. Thank you.
Thank you, caller. Can I briefly respond to that?
I think, why don't we take the rest of public comment before doing that? Is there any other public comment? Okay, seeing none, yes, Member Wong.
I just wanted to respond to say that this complaint actually was forwarded over to us because we were awaiting advisement from DCA Price Wolf. So that is why it got moved over to us before we could move it back to the full task force.
And Madam Chair.
Yes.
And just in my review of this case, the point around the time code was important to me as an expansion of the 67.8-1.
Okay. I think we are ready to call roll on the motion.
Yes.
Can I make a public comment?
Oh, sure. If you were having trouble getting through, yes, we will take your public comment.
Well, this is Chris Kors. I don't know if I'm allowed.
Oh, I'm sorry. No, you can't give public comment on your own matter. Okay.
No worries.
He'll have other opportunities when it goes back to the task force.
Yes.
Okay. All right. Sounds good. All right. Bye.
Thank you.
Just repeat the motion just to be sure it is correct. The motion is moved by Member Wolf, seconded by Member Wong, to refer the matter to the SOTF for hearing with a recommendation that the task force find a violation of Section 67.8-1 occurred for not recording the closed session in its entirety. The committee requested the following: requested that DCA Price Wolf provide advice on the matter prior to the next SOTF meeting for discussion of possible disclosure to the public. Requested a closed session policy, I should say recording policy. And if there are any rules for not recording the entirety of the closed session.
Go ahead.
And requested a time code of the complete meeting and the complete closed session portion of the meeting.
I would just say on the third one that it's the police commission's policy on recording of closed sessions.
Commission policy on recording of closed session. Sorry, I just want to get it down correctly. We'll just leave it at that. Just their policy on recording closed session.
Yeah, thank you.
On that motion, Member Wolf.
Aye.
Wolf, aye. Member Wong.
Aye.
Wong, aye. Chair LaHood.
Aye.
LaHood, aye. The motion passes without objection.
Thank you, everyone. Victor, please call the next item.
Next on the agenda is item number 6, file number 19131, complaint filed by Anonymous against Jose Cisneros, Teresa Buckley, and the Treasurer's Office for allegedly violating Administrative Code, sections 67.21, 67.24, 67.26, 67.27, by failing to respond to a request for records in a timely and or complete manner, failing to assist with withholding more than the minimally exempted portion of a public record. May I ask is if the petitioner and respondent are present on the line at this time?
Petitioner is here.
Is there a respondent on the line at this time?
Am I unmuted?
Yes.
We did hear you. Are you here as
Hello?
the respondent?
Yes, I am. This is Deborah Liu.
Thank you. We have both parties on the line at this time.
Madam Chair, a point of order.
Yes. Yes.
This is coming back to us because it was, I think I don't think I was on the committee at the time, but was this like a bunch of them that was determined to be within jurisdiction, and now we're just collecting information? Okay.
Yes. So there was many months ago, we determined jurisdiction for a large number of cases, but we have not heard the merits of this case. So we need to determine whether we have all the information we need, in addition to determining jurisdiction, to decide whether this should go before the full task force. And that's what we're doing today. So we'll just hear from both sides. We won't be debating. We are considering the information and whether we'll be sending it to the full task force.
Okay, I just want to note that the byline in the agenda says that this committee determined that the task force has jurisdiction.
That is correct.
Okay, thank you. Okay.
So if the petitioner is ready, you'll have 5 minutes to describe the case for us.
Please let me know when I may begin. Thank you. Good evening, Chair and members. This is case versus Jose Cisneros, the Office of the Treasurer Tax Collector, and Teresa Buckley. We can begin on the attachment for item 6 on page 6 of the PDF, or footer page P346. This is one of my long line of public records requests to every agency in the city to audit a certain standardized set of records, which includes a week of Prop G calendars, a week of non-Prop G calendars, both in the future and in the past, and then sent and received email samples from their official account of the department head and from their personal account if there are any records subject to the City of San Jose case. In this specific case, we have basically the standard set of allegations that they did not provide a certain set of future calendars. In this case, it's kind of strange. They provided them, then I think I told them that they provided them, then they unprovided them, and then they unprovided them again. So in this case, I actually know what is on the pages that they've officially not provided to me because I've seen those records. And this is a perfect example of 67.26, where some portions of the future calendar are clearly disclosable. They do not constitute security procedures of a local police agency, as told to you by both SFPD and the mayor's office. And those portions of the future calendar which do not constitute security procedures of a local police agency are disclosable. Now, they have cited Times Mirror Company, as all the other departments who come before you cite. This is bad law for numerous reasons. It came before, it was in 1991 and before Prop G. And what I did not know in my last few hearings about this same issue is that the governor has actually given in, and they were sued by the governor was sued by the First Amendment Coalition after Prop G passed in 2004, and the Governor Schwarzenegger did give the calendar records as a pretrial settlement, ignoring Times Mirror Company. So not only is Times Mirror Company bad law after Proposition G, it is also the case that it was an illegal citation at the time they cited it, because the Supreme Court only depends in Times Mirror Company on Government Code 6255, which is prohibited by SF Administrative Code 67.24 G and I. So these are all illegal when they cited it. And not only were they illegal when they cited it, Proposition G has invalidated Times Mirror Company. Now, there are a bunch of other issues in here which are very similar to the other cases regarding lack of email and calendar metadata, which you have multiple precedents on now. The fact that they did not provide electronic records as a copy, they printed and scanned them. And as you can see on page 349, which is page 9 of your PDF, Scanning and printing and scanning is not only technically not a copy of a record, which you've all done in the past, it's actually just unusable. You can't use a presentation when they give it to you in this format. And I can't know what the actual words or the chart numbers or anything is on this page. And that's just an example of the principle that you must provide electronic records as a direct copy of the electronic record. Otherwise, it's simply not a copy of the record. I think that's it. So there's 3 issues: future calendars, electronic metadata of emails and calendars themselves, and the fact that electronic records must be provided as a copy of the original record. That's it. Oh, actually, one thing. I don't know why it's not in the caption, but I allege not only Sunshine Ordinance violations, but as you can see at the heading of this complaint, CPRA violations, which are within your jurisdiction, and you should consider all of those violations if and when you forward this complaint to the full task force. Thank you very much.
Thank you. Is the respondent ready to speak?
Yes, I am. The anonymous requester demanded past and future calendar entries, as well as at least the past 5 emails sent and received by the treasurer. TTX conducted a diligent search and documents were produced, then redacted. We realized that there was an incorrect date that was corrected, and notwithstanding all of the different changes, the final production was timely made to this IDR. The treasurer produced the documents, all the documents with the exception of 2 redacted matters and no metadata. The redacted records included an assertion of the right to privacy exemption pertaining to personal email address and phone numbers. And then with regards to future meeting information with the mayor, we redacted that information, and our justification was based upon the deliberation process and the security interests of the mayor. Now, I know that there is some language in the administrative code that says we cannot look to the deliberation process necessarily, or balancing of exemptions. However, under the Times Mirror case, it seems like, although they may have looked at it to the balancing exemption, there is language in the Good Government Guide that says that this balancing exemption is not necessarily absolute, that the Sunshine Ordinance, in other words, doesn't prohibit a form of balancing where there is a balancing component. So in regards to the security interests of the mayor, I think that is not necessarily a balancing interest on its own, but you have to consider that that's what we're dealing with. The more important issue I think we're dealing with is the metadata that was not produced. We properly withheld all metadata on the grounds that there's basically no state law or legal authority to release the metadata under the Public Records Act. It's not clear that we have this obligation, given the fact that disclosure of the metadata may subject the city to security risk to its computers, networks, and lead to inadvertent disclosure of exempt privileged information. And there's other possible unintended results, such as hackers may penetrate the system, spoof its emails, and unauthorized emails of the cities didn't create, edit drafts, or insert themselves into attorney-client privileged communications. And I'm sure there would be comments or issues of, well, why can't we partially disclose? Our position is that if we disclose metadata, that may constitute a waiver of our right to withhold metadata in the future. So I think that we did everything that we could do in this situation, and we disclosed and produced all the documents properly and timely.
Is that the end of your statement?
Yes.
Okay, thank you. Task force members or committee members, do we have questions for the petitioner or the respondent?
I have a question for the respondent.
Please go ahead.
You just read into the record an interesting level of information regarding metadata. Who provided you with that information?
Who provided me with what information?
The information you just
About
read
what,
into
with the
with regards to metadata. Who provided that to you? Sounded like you were reading it.
I read it. I think I got it from a case.
Okay. Was this by your own research or did somebody else provide it to you?
It would be from my legal team.
From your legal team. Okay. All right. And why would do you feel that if you would disclose metadata that it would allow you to, would prohibit you from withholding it later?
If we disclose metadata on a certain area of a request, it could be somebody comes back and says, well, you gave it to us then. Why aren't you giving it to us now? You waive that right.
But that's for any public document. But that's for any public document.
Right.
So
metadata is, I don't know if
metadata is part of a public record.
Somebody can.
We've already determined that, but we'll get into that at the task force level. I just was curious as to who provided you with that level of information around metadata. It just sounded like a canned message, and I'm wondering if it's something that's being passed around from city department to city department. So if it was your own legal team, that's fine. That's something internal. That's different. I was just curious. Okay, that's all I have. Thank you.
Member Wong, I've lost some of the video here. Member Wong, do you have any other questions?
No, I do not.
Okay. Do we have a motion on this?
I move to refer the matter to the full task force.
I'll second that motion.
Okay. Do we have any public comment on this motion?
Sorry, I have my party, but I have a question. Have you found the records are public or not, or is that not what you do at this stage?
And we do. It actually, that was what in January was all about, was to find the records to be public and within our jurisdiction. If we didn't find them to be public, then we wouldn't be having this hearing.
To be clear, you have not found them to be public. You only found jurisdiction. That's what your notes say. But
I know that's what the agenda says. I imagine that if it got to this committee, that they were found to be public. That's usually the motion. Primarily is to find it to be public. Whether it's in jurisdiction or not is a different matter, because records can be public but not covered under the Sunshine Ordinance. So that's a different question. The primary question when we have these meetings is to find that the information is public. And I imagine, since it already had been gone through the previous process, that's what the motion was. What it says on the agenda, I'm not sure if that's verbatim. And I wouldn't declare that as being verbatim. But if you want to hold on for a minute, I can certainly quickly check. January 28th, 2019.
No, I just checked. Actually, you made the motion and Chair LaHood did and seconded it, I guess. And it says it is only for jurisdiction from your minutes. So.
Oh, I was at that meeting?
Yes.
You made the motion. I apologize.
Okay. That's that. I wouldn't say that it was in public. Okay, so then let's just reaffirm that here, or affirm it as part of the motion. That I'll amend my motion to find that the records are public and to refer it to the task force, and just remind us when we're doing those kinds of things. And frankly, it may have been the part of the recording of how it was written in the minutes. I'd like to go back and listen to the recording because it's unusual for me not to. The very first thing would be to find that the records would be public, not just jurisdiction. But thank you for pointing that out. It's now part of the motion.
Member Wong, would you like to amend as the second?
Yes, I would.
Okay. We'll take public comment on this. Are there any members of the public who would like to comment on this motion? Hearing none, let's call roll. Victor, we can't hear you.
Sorry about that. It's a common issue. On that motion, Member Wolf.
Aye.
Wolf, aye. Member Wong.
Aye.
Wong, aye. Chair LaHood.
Aye.
LaHood, aye. The motion passes without objection.
Thank you very much.
Thank you. Next on the agenda, announcements, comments, questions, and future agenda items by members of the Compliance and Amendments Committee. Are there any? Yes, please proceed.
Member Wong, yes.
Yeah, I just wanted to say that I meant to agendize a discussion of how sunshine could be applied to members of the government blocking people on social media accounts. But I think I misunderstood agendizing rules, so I didn't get it on the agenda soon enough. So I actually have a small presentation that I don't know if it makes sense to present at the next meeting for compliance and amendments, or if we want to share with the full task force. I think it's up to you all.
If I may, I would suggest that it be agendized because for kind of pertinent, substantive issues, we want to allow for public comment on that, and it would allow people to prepare in advance. And you should provide your presentation ahead of time for the agenda.
Great, will do.
Okay. Sorry, Madam Chair.
No, that would be great.
Chair LaHood, is that something you would like on your next agenda?
Yes, please.
Okay, I will let Cheryl know.
Thank you. Do we have any other items not on the agenda to bring up?
Nope, good.
Okay. Thank you, everyone, for being here today. Victor, please call the next item.
We would like to take public comment.
Public comment?
Oh, forgive me. Yes, thank you. We would like to take public comment on the last item that Member Wong brought up.
Yes, I'd like to speak on it.
Please proceed.
Please go ahead.
Yes. So if Member Wong is discussing the Knight First Amendment institute case versus Donald Trump, wherein they won the right that Trump cannot block persons on Twitter, that would be a violation of the First Amendment. I have actually made multiple records requests to the elected officials of this city, asking for their blocked lists, asking for their muted lists, to see if they have complied with Knight First Amendment Institute. And you will at some point hear cases about those issues before this task force. And I think it is a future amendment, a future agenda item. Since you're the amendments committee, also, I assume you you discuss proposed amendments to the Sunshine Ordinance. And I know that there are numerous persons before the in the city who have tried amending the Sunshine Ordinance. I will be trying to do the same thing, and I am happy to share my proposals with anyone, which include, at the very basic level, obviously changing this into a charter commission, giving that commission full subpoena powers, and then changing the supervisor of records role to no longer be done by the office of the city attorney, and the board of supervisors would appoint an external law office in order to do that procedure. But I'm happy to provide this for written comment if this committee does actually hear proposed amendments to the Sunshine Ordinance in a future agenda item. Thank you.
Thank you. Is there any additional public comment on this matter? See, oh, wait, yes, Member Wolf.
So I just want to, and also possibly of interest to the previous public comment, I just want to let you know that San Franciscans for Sunshine has been working on the latest iteration of amendments of the Sunshine Ordinance to do pretty much exactly what the public comment or part of it. There's a whole bunch of other amendments that are being done, and would welcome, you can contact them through their website at San Franciscans for Sunshine, all one word, .org.
Thank you.
Thank you. I don't think we're going to have any additional public comment because I don't think there's anyone else available on the line. So, Victor, if you could call the next agenda item, please.
The next item on the agenda is adjournment.
Okay.
Move to adjourn.
Seconded.
I think we can take it by acclamation. Thank
The
you,
meeting is-
everyone.